Hello, and thank you for watching our pre-recorded webinar. All information was correct at the 19th of May 2022. In this short webinar, I will look at the new mandatory online right-to-work checks for employers from the 6th of April, together with the proposed digital checks for British and Irish nationals. Plus, I will also recap on the manual checks and the use of the employer checking service for employers where they cannot use the online right-to-work checks. I will also look at the different right-to-work web pages for an individual and the employer. These pages are very similar, so it's really important that employers keep the appropriate check on file, which will be allocated a Home Office reference number. Now, this move to full digitisation for right-to-work checks in the UK will also impact landlords checking immigration status for their tenants. This is known as right-to-rent checks. Let me introduce myself. My name is Imelda Reddington. I am Head of Immigration at Field Seymour Parks, where I've now worked for just over 2.5 years. We offer a range of free webinars, seminars and podcasts at regular intervals throughout the year for immigration and many other practice areas across the firm. We also have a number of regular bulletins. Details of how you can sign up for any of our legal updates are set out at the end of the presentation. As an immigration team, we also offer bespoke training and workshops for complicated processes such as right-to-work compliance, sponsor license compliance, and we have a bespoke service to assist registered sponsors with the management of their sponsorship management system and their migrants' visas. So let's look at today's content. There are 3 acceptable methods for checking right-to-work in the UK. There is the manual or physical check, where an employer views an original document in the presence of the candidate or via video conference. There are the online checks, where an employer uses the share code that's generated by the individual or the candidate from their UK VI account. And there is the employer checking service, where an employer is requesting a check from the Home Office using the visa application reference number or appeal reference number provided by the candidate, and then obtaining a positive verification notice. So what are the changes that have come about from the 6th of April 2022? Well, the first change is that online checks become mandatory for many migrants, those with a biometric residence permit or a biometric residence card, a frontier worker permit, or those with status under the European Settlement Scheme, or those who are applying and have a digital certificate of application. Employers can no longer accept any of these documents as evidence of right to work, and failing to maintain compliance with the right to work law could result in civil penalties or other sanctions. The second change is an optional change for employers to use an approved third-party provider to validate ID documents only for British and Irish employees to perform the right to work check. I will talk a little bit more about these checks a little bit later on. So who do the new checks apply to? Well, they apply to any new recruits starting employment from the 6th of April 2022, or those who require follow-up checks if they are an existing employee and have a time-limited visa. Please note that this also includes those with pre-settled status under the European Settlement Scheme. There are some new resources available from the Home Office that will assist you in understanding these new changes. There are 2 links on the slide. The first one is to the latest right to work guidance for employers. So please do take time to review the new list A and B, which is set out in the guidance document. And the second link is the link to a portal to assist employers understand what documents they need to prove a right to work for the particular employee or candidate. Now we will look at the different web pages for the individual and the employer, plus show examples of the results from each page. As I said earlier, it's really important that the employer retains the correct check so that they can maintain a statutory excuse. Let us first look at the employee status page. The link is set out on the slide. This is for an employee or an individual to obtain a share code and provide it to their employer manually, or to generate a share code and send it directly to the email that the employer has provided. Now, most migrants who have been granted e-visas will have a UK VI account. Those who don't have a UK VI account can create it with a particular document, either their passport or their biometric residence card. The employee or the candidate must first access their UKVI account to view their status, and they will then be able to share it or provide a code to the employer. Now, in order to access their account, they will need the ID used to register for the most recent visa, which could be an old or expired BRP. So ensure if you're an individual accessing your status, please have your document available, or at least a reference to that document available in order to access the account. This is the screen that the link will take the individual to. It sets out what is required before access, and then obviously a link to start the check or the proving of status. Clearly, the document on the page sets out the immigration status. It says it's to view and prove your immigration status. This is for the individual. An employer cannot use this page as evidence of right to work. It sets out the name of the individual, a photograph on the bottom right-hand side, the visa type held, the validity and the expiry, and at the bottom of the page it sets out prove your status. So there is a link in grey where the individual can share their status with an employer or another third party who needs to see their immigration status in the UK. The second page of the right to work check sets out the legal basis of the migrant's stay in the UK, and a reminder to change any personal details when required or as they change. It's really important that email, phone number, home address and passport details are changed. If an individual receives a new passport, it's really important that they notify the Home Office using their UKVI account, as it is the information that's linked for return or entry into the UK. If you get a new passport and it's not on the system, you could have a little bit of a longer wait at the border if you're returning to the UK after travelling. Now let's look to the employer link. Clearly the link says view right to work. So this is for the employer to check the candidate's right to work in the UK. Very similar screens to that for the individual. And again, it clearly says view a job applicant's right to work in the UK. It could also be an existing employee who needs follow-up check. It sets out what you'll find and reminds the employer that they will need a date of birth or a right to work share code. If the candidate or individual has decided to share the code via email, the person whose email the code was sent to will receive a link to a similar page as this so that they can undertake the right to work check. So for the purposes of checking right to work from an individual, this is the page it will take you to if the individual has provided you with a manual share code. So please get their date of birth also. This is the page that shows the candidate's right to work. It doesn't have a heading as the individual page did, but it does have the individual's name, which I've redacted for the purpose of the presentation, on the top of the page, plus the photograph on the left-hand side. It sets out the permission they have in the UK, and also some details on conditions, including whether they can work part-time and the number of hours, etc. The second page is for the employer to complete. You're expected to ensure the person looks like their photograph when you meet them face-to-face. If two separate people are checking this, I would recommend that you add a note of the times that the checks were conducted and record a PDF on file. You're also reminded that the check needs to be kept for 2 years after employment has terminated, and again a reminder to undertake this check when this current permission expires. We do recommend that you add this date to a shared calendar with relevant reminders at intervals of 3, 2 and 1 month before the visa expires, so that you can follow up with your employee to renew their visa before their current one expires. On the right hand side you have the company name, again, which has been redacted, the date of the check and the reference number. This reference number has been generated by the Home Office and is proof that you have undertaken the check. So obviously the check is required before employment commences, and if for any reason you are missing this document or it's destroyed in any way, the Home Office will have some form of reference number to show that you did undertake the right to work check as appropriate. I will now recap briefly on manual checks for those who still need a manual check. So this could be British Irish nationals or those who don't have one of the documents I mentioned earlier. Employers must carry out a valid right to work check, again, before employment commences, and they must only accept documents listed in A or B of the guidance. So please review it as it has been updated to remove European passports, etc. Obviously, the check must be conducted in the presence of the holder or via video conference call, and the records must be kept and retained on file for duration of employment and 2 years afterwards. If you as an employer are undertaking checks, or you instruct an agent to undertake checks on your behalf, the responsibilities can be delegated, including any penalties that may be imposed for failing to undertake the checks appropriately. Please note that COVID concessions are still in place until September 2022, so you can still use copies of documents to undertake checks, but remember from the 1st of October, if it's not mandatory to undertake an online check, you must have processes in place so that you can either view an original document or see your potential employee in person to have an approved manual right to work check. Where a manual check or an online check is not appropriate, some circumstances employers can use the checking service. There is a link to the portal on the top of the slide. It can only be used obviously in some circumstances where an employee has submitted an application before their visa expired, or they have an outstanding appeal or administrative review. Part of the process, the employer is required to enter the application, the unique application reference number for the either the visa application or appeal, and obviously they need consent from the individual before submitting this check. The employer must obtain a positive verification notice in order to continue with employment. If a negative verification notice is received, please review carefully the information contained and seek some legal advice. Positive verification notices are only issued for a period of 6 months. So if your employee has not provided a relevant visa after that 6 months period, or they haven't had an update on their review or appeal, you need to be repeating the check to obtain a further statutory excuse once this PVN is expired. And we would recommend that you're diarising follow-ups for PVNs in shared calendars, as these can catch up on you quite quickly, and some appeals can take more than 6 months to reach a decision. These are examples of the positive and negative verification notices you may receive from the employer checking service. Positive is green and sets out the information of the check. Negative is red. Read carefully and seek advice if you need to. I'm going to look at the optional checks that were put into place from the 6th of April for British and Irish nationals to undertake digital right to work checks. This IDVT, or Identification Documentation Validation Technology, establishes authenticity of documents such as passports or biometric residence permits for identification verification purposes. Employers can now engage services of ISP providers who can use this technology to carry out the verification and the eligibility elements of the right to work checks. The employers who follow the guidance will avoid any penalties and establish a statutory excuse. So what employers need to know about the checks available to British and Irish nationals: they must use a valid British passport, Irish passport or passport card. If they don't have a valid document, they can revert to manual checks. The employers are responsible for checking the names on the ID document. The employer must also confirm that the images provided match the employee likeness. So there is an expectation that you see the individual in person or via video conference. And there will be no statutory defence if the employer fails to follow the guidance appropriately. If you cannot meet the requirements as set up above, employers can undertake the check manually. Remember, these are not mandatory. They are still optional, as the recommended providers have not been put forward to a list on by Home Office just yet. So we expect something to come in before the 1st of October, but watch this space, and we will share information as it becomes available. Well, that concludes my brief update today on right to work checks. If you need any further information, please contact me. My telephone number is set out on the slide. My email details are also on the slide. And please do connect with me on LinkedIn. I share information regularly in relation to Home Office updates. And finally, if you'd like to sign up for any of our regular legal bulletins, the link is on the bottom of the slide. So I'd like to thank you all for joining us, and have a good day and week ahead. Take care. Bye-bye.